Is live, uncut, unedited.
It's my
Tell
personal
the
thing.
truth and shame the devil. I love being black.
That's my motto, y'all. All right, people, we coming live right here from Teamwork Englewood, and y'all can say hi to the people in the camera,
Hello.
the cameras, and we got a great subject, as I warned you guys earlier today, I believe last night as well, that we're talking about eviction today. So also we're taking questions. We're just taking like general questions. We're not going to go too deep. Now, if you need to go too deep, we're definitely going to leave the number here. Let me make sure I got that title right. That title is, what's the title?
The Law Center for Better Housing.
All right, that's right, legal aid.
Yeah.
Legal aid. So come on in, people. This is live, uncut, unedited. I'm going to introduce everybody in 1 second. Matter of fact, we'll start with our guest right here first.
Okay.
Go ahead.
Go ahead.
Hello, everyone. My name is Jacqueline Spreadberry, and I am a staff attorney at the Law Center for Better Housing.
Okay.
Hello. I am the attorney here for Teamwork Englewood in the Records Relief Department.
All right, everybody. And you already know who I am. No, it's Vera. This Vera Giles Norris here with my partner, letting the cat out the bag, uncut and unedited.
All right, y'all know my name is Martin G. Johnson, aka The Crime Chase. We're live on YouTube, Twitter, and Facebook at the same time.
At the same time.
So the call-in number is 872-297-6389 or 872-299-0808. So we're gonna get started, and you guys, we're gonna start with a question.
Let's start with a question.
We're gonna start with a question.
As a matter of fact, I'm gonna go ahead and kick it off. Our first question. Well, first of all, you know what? You kind of gave a little bit about yourself.
Yes.
But if you could just kind of go in a little bit, deeper about who you are, why are you here today, and what can the audience gain from listening to you today? And start with valedictorian, if you don't mind.
Oh boy, yes. I was valedictorian of my law school, UIC Law.
Yes.
Thank you. And yeah, I am a staff attorney at the Law Center for Better Housing. We do eviction defense work in hospitable living conditions, and advocate for fair housing for all. And so I'm here today to talk about the eviction process, what people can kind of expect, and just a general overview of what it's like, and tenants' rights and tenants' remedies.
Okay, so you know what? Here's our first question. Go into detail about the kinds of services that your organization provides. LCBH. Go ahead.
Sure. We do have an intake line that people can call, and if they're having issues with their housing, specifically conditions issues where the landlord won't fix very severe conditions issues. And then we also do, we staff the early resolution program. It's a program in the Cook County court system that helps pair tenants with attorneys when the tenant would otherwise be unrepresented in an eviction court. And there's also a legal aid provider that pairs unrepresented landlords as well. But it's just our organization does the tenant side of eviction cases. And so we help with the early resolution program. And then we do a lot of policy work, promoting fair and equitable housing rights.
Wow. So
Real quick, the telephone number. I think I got it.
Go ahead.
Oh, yeah. So the Law Center for Better Housing has an intake line. It's 312-347-7600.
Okay, I put it up there. I got it.
I got it up there?
I got it up
And
there.
it is closed for the rest of the year, but you can call starting in January if you need help and assistance.
All right.
Perfect.
All right. So you know what? Go ahead, Marusa.
Okay.
Give us another question, please.
Yes. All right. So, Jacqueline, can you walk us through an eviction proceeding? Just kind of tell people what eviction means if they're facing that particular problem, and kind of explain how someone can go about starting a claim if they have an eviction notice filed against them.
Sure. So if we start from the beginning, an eviction proceeding is a court proceeding where the landlord is alleging that the tenant either doesn't have a valid tenancy or overstayed their valid tenancy. So before an eviction case can be filed, there has to be notice so there's a valid tenancy, and there would be a lease, either written or oral. So if you never filled out a lease, you probably have an oral lease, because the law says that you have to have a lease. And so first there has to be notice from the landlord saying we're ending this tenancy, and that notice can come in a variety of ways. So it's a 5-day notice for due and unpaid rent. So if rent was due and it hasn't been paid, the landlord can give you a 5-day notice and say how much is owed.
Okay.
And then the name kind of suggests it, but you have 5 days to pay that balance, and the landlord has to accept that, and then your tenancy continues.
And is that balance usually your standard rent? Like,
Yeah.
can they? Okay.
What about late fees on that?
Yeah.
The late
They
fees.
can
is-
put
Yeah.
late fees. Okay.
Except in Chicago, there is a limit to how much landlords can charge in late fees.
Okay.
The limit is it's $10 for the first $500, and then 5% of any rent amount over $500.
Oh wow.
So there's a little math involved
Oh,
in there.
Yeah.
I need to write that down.
But if you're getting charged like $200, $300 late fees, it's probably not allowed under the residential landlord tenant
Oh, they
ordinance.
inflating.
Good to know.
Yeah.
No.
Okay. I got a question that's not on the list here, real
Okay,
quick,
go ahead.
real quick. I also did an interview like this, and when you go fill out, I just want to change the subject real little bit. When you fill out an application for housing, is it illegal for the landlord to ask you if you have a criminal background? Yes.
In Chicago,
Yes.
yes.
Okay.
And I got a question. And it's
I
so
think
Let's
I'm gonna say I think.
Okay.
it
You don't
is.
know. Okay. If you know,
We tend to not do, and you might know better,
I can look it up because I
Okay.
actually don't know that either.
okay.
because we tend to do
Just
the eviction
Right.
and not the application
Right.
end of housing work. But I think it is.
So they cannot ask the applicant whether they've been convicted of a crime.
So, because I think the order is they fill out the application first, and if they pass the application, then the landlord can ask them in that
makes
order.
sense.
That's why I say that. Okay, go
Yeah.
ahead, Vera.
Okay.
That's
Yeah,
all.
I think so.
Okay, okay.
Yeah.
All right, I didn't mean that
No,
charge
that's
question.
fine.
Okay.
Okay, so no, but that's a really good question because people don't need to know. I got one that actually came into my inbox maybe about 3 days ago. Someone was asking me, and so I may be jumping the gun, but if so, let's stop me and we'll backtrack. So these people had the 5-day notice.
Mhm.
I guess they were evicted, and what's supposed to happen is that the locks was changed. So now these people have belongings inside the house. Would you be able to give information if the landlord is keeping them out of the house with their belongings in?
I would say that if they received just a 5-day notice, and then on that 6th day the locks were changed,
Yes, sir.
they should call our intake line, because that's just not how the eviction proceedings work.
Okay.
That would be a self-help remedy, and those are not allowed.
Okay, well, thank you. And it just so happened that question came in. So let's just go ahead and get back on track here with some.
So after the notice, that's kind of where we left off.
Yeah, and there's other types of notices for other issues. So if the landlord's saying you violated a different part of the lease other than paying rent, that's a 10-day notice.
Oh, okay.
Okay.
Oh, I learned something today.
So
I didn't-
like, let's say your lease, this is an easy example. Let's say your lease says no pets,
Right,
and the landlord finds out you have a cat.
right.
The landlord would give you a 10-day notice saying you're in violation of this part of the lease, and you have 10 days to fix it.
Wow.
Okay.
Okay.
Okay. So find somewhere else for your cat to live, or I don't know. So you would have 10 days to fix that. Otherwise, eviction proceedings can can
Okay.
start. The third type of notice would be just notice of non-renewal.
Okay.
So this is like your lease was for a year, we're done, the landlord just wants to not renew it, or you're on a month-to-month tenancy. It's 30 days it's a 30-day notice if you've lived there less than 6 months. It's a 60-day notice if you've lived there more than 6 months but less than 3 years. And it's a 120-day notice if you've lived there for more than 3 years.
Wow. I had to go back and listen to that.
I know.
I'm gonna have to go back. That's it. You just woo. Just a question I have. Now I've been through the eviction process.
Okay.
Now you have. I'm just personally. I have a friend that owns like 300 some units, and he told me personally that he doesn't rent to anyone that have an eviction unless it's 5 years old. Is that legal or? Okay.
Yeah.
Okay. I just want to know. Okay.
Right. Okay. And
Why?
and you know what? And speaking of, I guess we can go to the next question. Does that show up on your credit?
It can, yes.
Okay.
So once an eviction case is filed, that would be you've got that notice, you were unable to cure the notice, and you overstayed the notice. Okay, so that's when the landlord has the right to file the eviction proceedings. So like actually file a case in court. And that eviction becomes part of the public record,
Mhm.
regardless of the outcome, unless it otherwise gets sealed.
Oh, okay.
And even if it's dismissed with prejudice, dropped, it would still show up in the public records as such, and is an eviction filed against you that was dismissed, unless it gets sealed.
Oh, wow. Okay.
I didn't-
That's kind of.
Yeah. And are people aware of this when they're going through the process that there's a potential of this being on public record?
I mean, generally, I think people just want to get it sealed, so
Okay.
that can be part of negotiations.
Yeah.
And we try to get as many cases as we can sealed, especially when the landlord gets paid either through rental assistance or otherwise. We come up with a really good settlement.
Okay.
So it can be part of the settlement. But yeah, if you don't get the case sealed, it'll stay there.
Wow.
So let me ask some questions from the audience, and I apologize to you all because I was not paying attention. But let me go back to one of the first questions: is what this person says, what can I do because my landlord keeps on harassing me to move even though I'm still paying my rent?
Some of these like specific questions can be kind of tricky. I feel like.
Yeah, and I also I can answer like general questions, but I can't give actual legal advice because you shouldn't take legal advice from a podcast.
Right. That's perfect.
But yeah, so the landlord can issue a notice if they're not renewing the lease, right? If they want to end the tenancy, then the landlord's right under the law is to issue said notice as long as the lease is month to month at this point. If there's like a valid lease that's a year long and we're only 6 months into it, then they have 6 more months as long as they're not violating any terms of the lease.
And then I guess the second part of that question is, does it matter where the rent is coming from, if it's Section 8 or if they're personally paying? Are there stipulations?
I think it might depend what the lease says, but short of the lease not specifying, then I would think not, but I'm not certain.
Okay. So
Yeah.
you know what? Let's go. I guess we can go to our next question. You
Yeah.
guys clear right here?
But Claire, I want to go back to the eviction real quick on your
Sure.
personal. So even if that eviction is satisfied, say like you owe your landlord $2,000, but you satisfy it, and if you go apply for another apartment and they pull it up, say, well, you had eviction back in October of last year, but I mean, they said, well, we can't accept, but it was taken care of. So, I don't know. That's the landlord. That's
It's
tricky.
unfortunate,
Yeah.
and it's allowed.
Yeah.
Yeah,
Wow.
even if it's dismissed with prejudice,
Okay.
which means
Right.
you've taken care of it.
Wow.
Okay. So you know what? I guess we're talking from a tenant's perspective from this next question. But what constitutes safe apartment living condition?
Yeah, so the landlord has the requirements under the law to provide safe and habitable living conditions, which includes heat from September to through May. I think it's September 15th through June 1st. The landlord has to have heat that heats the building to 68 degrees during the day and 66 degrees at night. And then you have to have utilities. You can't have, like, you need working fridges, working stoves, basically anything that is required for living,
Living
right?
condition.
Running water.
And I would like to stick a pin here. I would guess unless the landlord says that they're not responsible for the refrigerator, stove, and then they have that in the lease, then they don't have to provide that. Or do they? So that's
I'm actually not 100% certain. If the lease specifically says no fridge, then I think it might be your responsibility to supply one. But I'm not sure if the landlord is
Can
required.
write that in the
Yeah, I'm not sure.
well, okay, so
Sorry.
Right.
well, I just know that some apartments
Right.
come or if you're renting a house, for example, I know that sometimes it stipulates bring your own refrigerator, bring your own stove.
Yeah.
But anyways,
Yeah, I'm not actually sure if they can do that. I would
Okay.
have to look it up.
Okay.
Okay.
Well, because I
One
know
question.
there's some apartments where like there's no microwave provided,
Right.
and like you have to bring that on your own.
Yeah, I would think that a microwave isn't going to be considered
No.
like necessary.
requirement
though.
for
Someone
Yeah.
asked a question. You guys, you're welcome to call in if you like. Oh, you know what? I haven't even put the call in number up. But let me just say this. Somebody said, what if you lost your job, but you're willing to pay your landlord when you get the money? Now, that's kind of...
You're always more than welcome to talk to your landlord and try to negotiate something on your own, right? Before a 5-day gets issued, before the landlord files an eviction case. That said, the landlord doesn't have to negotiate with you, and the landlord can just say, I'm issuing the 5-day notice because you're behind in rent, and then I'm filing this eviction case on the 6th day. Like, they can do that, but they might work with you. I mean, I think it depends landlord to
This is
landlord.
Martin G.
I'm sorry. I'm
Okay.
making sure they didn't call in. Okay.
no, you know what? It's some pretty good questions coming through, and some of these questions are real
Yeah.
specific. So we may be going a bit deep, but I want to just go to this question because it kind of, I've heard it before. It says, if you were waiting 13 years for a low income place and finally get it and fill out your lease, can you get denied the apartment if you owe the gas company and they give you only 3 days to pay? That may not be in this ballpark here, but that may be a little bit technical, but I wanted to ask
I
him
don't
if it is.
know.
Okay.
That's a good one, too, because some of us do have outstanding gas bills.
Yeah,
you know,
we do.
and some places when you rent them, they want you to pay your own gas. So they figure if you can't get no gas, you can't rent. So that
Yeah.
So I guess because again, we're talking about eviction, but so much stuff comes with that.
Yeah.
So just for the sake, we're gonna stay down the eviction road.
okay.
Okay, we gonna and remind me when y'all with the questions. I just wanted to be fair, but we're gonna stay over here with the evictions. We'll get to the gas company maybe later.
And to be fair, I don't do subsidized
Okay.
eviction. That's a whole different
Subsidized.
subsidized housing eviction.
Right.
I don't do that.
Oh, okay.
So I don't really know a lot about subsidized housing law.
Okay.
Unfortunately, I'm sorry.
Nope,
Okay.
that's good because that question was one of the questions was based on Section 8, and that's what she was asking. So at least we know.
Yeah.
Okay, so let's go.
But I would
here.
encourage them to call either Carpels or Legal Aid Chicago, because Legal Aid Chicago handles the subsidized housing.
Okay, and then we already said the number. You can say it again to report issues related to the conditions of your living space. We already said that same number, right?
Yeah, the 312
312
347
347
Oh,
Yeah.
7600.
that's our intake line.
Okay.
That's like if you're calling because you have like an actual legal issue. If you need to report conditions issues, the best place to call is 311.
311, yeah.
Always call 311 and report those conditions issues.
Okay, so there you have it.
Yeah.
Marissa.
Yeah.
So the other important thing about conditions issues is you have to notify the landlord in writing. In writing is the best way. Also, you can call 311, but notify the landlord in writing about the conditions issues first. And the landlord has 14 days to fix them. Okay. If the landlord doesn't fix them by the 14th day, then on the 15th day, you can start to do one of two things. You can withhold rent in the amount that the conditions lowers the fair market rental value of the unit, or you can fix it yourself and deduct the cost of fixing it from your rent.
And that's only after you've given them notice, correct?
Right.
Correct.
So
and waited 14 days.
Is it, what about if you send them a text or email?
Good question.
Yeah, because see, you need something concrete
Yeah.
proving that you sent it to the
That you sent
landlord.
it.
Yes. The really difficult ones is like, well, I always call my landlord.
Right.
Well, that's not definitive proof that they were notified.
So just to be clear, text and email, of course, is documentation. It works.
Right.
Yeah.
Writing.
Perfect.
Also certified letters are great.
Yeah.
And you
Yeah.
can go to rentervention.com. It's a website that the Law Center for Better Housing helped create.
Say that again.
Rentervention.
Spell it out.
That's what I was gonna say. Please.
Yeah.
Uh-huh.
I know, I gotta do
Google
the
it.
same
Google
thing.
it.
rentervention, rentervention.com. And it's powered by AI. And
Okay.
Rennie, the AI bot, will help you write a 14-day letter for your landlord.
Oh.
So he'll ask you what conditions issues you have, and you can tell Rennie, the bot, and he'll draft a 14-day letter for you. And then you can even have him send it off.
Oh, wow.
Okay.
So
Oh, nice.
And spell that one more time for us again.
rentervention. Rentervention.
Make sure you guys share this video because this is some valuable information. Trust me, I thought I knew all the rules, but I didn't know. I'm learning something different today now. Wow.
Yeah, and then so you can go there to get the 14-day letter. The bot can send it, or you can send it, and then also call 311 to just make sure that notice is given.
You're covering all your bases.
Right.
Exactly.
So other words, don't go out there because your hot water's not working and spend your rent up. Spend your rent money.
Right. You got to follow
There's a
the
procedure.
follow
There's
the
a
procedures.
procedure.
Yeah, follow the process.
Mhm.
Okay.
Okay, so I have a question. I guess we talked kind of about the notice that the landlord is required to give you. So just in general, how long does it take for an eviction to kind of go through the court process? And like, what are those steps for people who might be kind of, court is scary and not everybody is fully aware of what process is going to go down, what judges are going to ask them. So can you just tell us a little bit about that?
Sure. I think the biggest takeaway is for tenants to go to their first court date.
Okay.
Please go. We really encourage that because you'll get paired with somebody in the early resolution program. So the judge will pair you with ERP, early resolution program. It pairs staff attorneys like myself with tenants who are not represented in eviction court, and then we can evaluate your specific case and see what's going on in your specific case, give you legal advice, help you negotiate, and just give you guidance along the way. And so that happens though when you go to your first court date.
Okay.
So prior to the first court date, so the case gets filed, then the plaintiff has to serve you, right? Give you the summons, which is going to have that first court date on it. So then you go to your first court date, you go to ERP, you talk to an attorney, either from the Law Center for Better Housing or a different legal aid provider, depending on your specific circumstances, because we all have different specialties. And then if it's not settled, you'll go back to your next court date, and that's when you'll get transferred to a courtroom. And in that courtroom, that's when you would get into specifics of like if there's any motions that need to be filed, anything like that. Otherwise, it'll get set for trial. So ERP can take a couple weeks.
Okay.
And then the transfer takes another like 2 weeks. And then setting it for trial takes another like 2 weeks, and then the day of trial is actually the last day you have for the right to cure. So everybody in Chicago has a right to cure, as long there's some circumstances where you don't, and it's where the landlord lives in the building with you, basically.
Can you kind of explain what the right to cure means?
Yeah. So the right to cure is for people that are facing eviction for unpaid rent, and you have a one-time right to cure, which means you could pay everything owed plus court costs, but not attorney's fees. The landlord has to accept it and renew and revalidate your tenancy, and then you can continue to live there.
So, okay, I have a question too. So,
Sure.
I've been through that before, and I stayed another year, and it worked out perfect. So, does that eviction still stay there, even though you?
Yes, unless you get it sealed. And you can ask for it to be sealed,
Okay.
and it kind of depends on the situation and who your landlord is, and yeah, it depends on specific situations and circumstances. But yes, if you don't get it sealed, it would still be there.
One more question,
Go
Peter.
ahead, go ahead. No,
I'm
no,
sorry.
no, go.
I'm sorry. I had a friend that was going through eviction process,
Mhm.
but he'd never been served.
Mm-hmm.
So it was like avoiding the landlord and avoiding the landlord. And I was like, man, eventually you're going to come home one day and your stuff is gone. So how that works, you know?
Yeah. So service is what is required for like due process, right?
Right.
If a defendant has the right to know about a case that's being brought against them. And so the plaintiff, the landlord, and their attorney have to take reasonable steps to notify the defendant. So in Chicago, that means the sheriff will come and bring you papers.
Mm-hmm.
Okay. And the sheriff will try like 2, maybe 3 times. And if you're not home, then they'll get a special process server, which is like a everyday person. It's like somebody who does it for a living, but they're not a sheriff.
Right.
Right. And they'll come and they'll try a couple times. And if you're still not home or they're still unable to serve you, then, and they can show that they tried a reasonable amount of times at different times, different days. They can't just come at 3 p.m. on 5 days in a row. Right. They got to try at different times. And if they're unable to, then they can do what's called service by posting.
Okay.
Which is where they post it in the Daily Center.
Oh, okay.
To notify you of your court date, and then they also mail you like your court date in the mail.
Yeah.
So there is, it would go to service by posting, and then you would be expected to show up at your next court date. And if you don't show up to your court dates, then the landlord can get what's called a default eviction, which is where they have an eviction order that they can give to the sheriff. And then that's the order that when the sheriff comes out and evicts people with. And if you do get a default eviction against you, it's fairly easy to undo that within the first 30 days. But that 31st day, it is really difficult to undo a default.
So
Wow.
timestamps with housing.
Ooh.
It seems like
Yes.
you have to do this within 14 days, this within 30. So don't avoid your eviction notices if you are getting that.
Lesson learned.
And to just go back and finish up you at the eviction proceedings.
Yeah.
So you have the right to cure up until that eviction order.
Okay.
If you lose at trial, then the landlord's going to get that eviction order. That's what they can take to the sheriff. And then the sheriff would come out and carry out that eviction order and like physically remove you from the unit. And that itself takes a couple weeks.
Yes.
So it's not instantaneous.
Question. Now you got this thing, and this is me. You have some people say, well, they can't put you out in the wintertime, but I've known them to lock you out of the house and you have to make an appointment with the landlord to get your stuff, your belongings out of your house.
So the sheriffs they currently have a moratorium on evictions. It just went into effect, I think, yesterday.
Let's hear it.
It's December 18th through January 2nd.
Okay.
So it's significantly more limited than wintertime. And then they also won't evict people when it's colder than 15 degrees outside.
Okay.
Or there's other extreme weather conditions.
Okay.
But it's not a moratorium on evictions in all of winter.
Mm-hmm.
It's just when it's colder than 15 degrees and then that 2-week window.
Wow, y'all hear that now? To pay your rent or move out.
Yeah.
This is a motto. A landlord used to tell me. A friend of mine. He said, "If it's good enough for you living, then it's good enough for you to pay rent." So, hey, that's
That is
it.
a pretty good motto.
And we went over this question,
Mhm.
but what constitute an illegal lockout? But I want to, you know what? Let me do this because I want to go back. I
Great
had
question.
someone call me, and they had the monies for the rent. They had the court fees and all of the other stuff that was needed. There was an outside organization that was going to help them pay also, but the landlord refused the help from the outside organization,
Hmm.
and he needed the tenant, and he did not, because it was a process for the outside organization. So let's say the outside organization needed this, that, and one of the things being that that the landlord would agree to take their monies. And it's a process, 30-day process for that.
Mhm.
But the landlord said no. So this,
Are you talking about rentals, court-based rental assistance?
Yes, some similar.
that's what it was.
Because I'm not familiar with the rules around like nonprofits. Like there's a lot of little rental assistance which are great. Like shout out to all the people that help with rental assistance. And the only thing I can speak on is the court-based rental assistance program, which is specifically for people that are in eviction court.
Mhm.
And for that, the landlord does not have to agree to participate in court-based rental assistance,
Okay.
but a legal aid provider can help people when the landlord refuses to participate. So there's one thing that I do as a staff attorney at the Law Center for Better Housing is help people still get that rental assistance when the landlord otherwise refuses. It's a slightly different process, but it's still available.
Oh.
And that's what people can use to assert their right to cure. But it is a one-time right to cure per landlord-tenant relationship. So you get to do it once, but then if you get behind again, the landlord doesn't have to accept it the second time.
Man,
And with this the rental assistance that's provided through the court, do you only get that if you're showing up at your court date and you meet with an attorney? Or is there a way people can know about it or go through that process without going to their court date? Which, I mean, you should always go to your court dates, but...
I know that if the landlord participates, some people have the application completely filled out before they ever meet with me.
Okay.
And that's great. So it doesn't require an attorney to fill out the application when the landlord's agreeing to participate. But if the landlord doesn't agree to participate, it can get a little more complicated.
Okay, so you know what? Let's flip the script. Talk to us about late fees and security deposits.
Sure.
Oh yeah, perfect.
Yeah.
We got
Okay.
all about that.
Well, I mentioned late fees a little bit earlier, but there's a cap to how much landlords can charge in late fees. It's that math equation I mentioned. So you might want to get your calculators out, but you take your rent. The first $500 of your rent, they can charge $10 in late fees. And then they get to also charge 5% of the remaining amount after that $500.
Okay.
And that's the most they can charge. And anything else is not allowed under we call it the RLTO, the Residential Landlord Tenant Ordinance.
Wow. And do you lose your security deposit if your eviction proceeding
Mm.
goes through?
I know a little bit
That-
about
I don't
that.
know about
I know about that.
You do know about that?
I think I know a little bit about that.
Okay.
Yeah, actually, the security part deposit is not for the rent. It's part of damages and things like that. So
okay.
you would have to have like I had went through that, and they had to return my security as long as there wasn't no damage or anything to the apartment. But you have to request, you have to say something, and you're supposed to get it back with interest too as well. If it's nothing, yeah.
Wow.
They have to put it in escrow. That's what they're supposed to. Yeah.
Wow.
They have to, okay, yeah. So landlords have a right to keep your security deposit if there's excess damage to beyond normal wear and tear.
Right.
So we always say leave the apartment in broom swept condition.
Take a picture, video.
Take pictures.
Mhm.
And then also the landlord can keep the security deposit if there's past due rent
Okay.
when you move out to cure that past due rent. Short of that, the landlord doesn't have the right to keep the security deposit. So if you're fully paid and you leave it in good condition, minus normal wear and tear, then the landlord has 45 days to return the security deposit to you.
Correct.
And if he or she subtracts any amount, they have to kind of document why they subtracted that. However, you have to notify them where you would like it returned to.
That's
and
correct.
if you don't notify them where you would like it returned to, then they don't have to return it because they don't know where to send it because you're not living there anymore. So it's always good to send a final email, final text saying I'm out, I left the keys here, and this is where you can send my security deposit.
Right. You know what I noticed too? Like when landlords take you to court for the past due rent, they never subtract the security deposit in that, but they always keep that. But when you get that eviction and it's on your record, it's for and that amount is inaccurate actually.
Yeah.
They don't have to subtract the security deposit
Okay.
when they first issue that 5-day,
Right.
and they are allowed to keep it if when you move out you still owe them rent.
Okay.
Yeah. But they do have to keep it in an interest-bearing account,
Mm-hmm.
and they have to pay you that interest upon returning your security deposit. And they have to let you know what kind of interest-bearing account they're keeping it in, and they don't have a right to waive that.
Okay.
So the lease can't say we're not keeping it in that
Yeah.
interest-bearing account.
Wow.
Wow.
And I'm probably going back. This may have been addressed. When is rent late? Who determines that?
Oh, yeah.
The lease.
The lease. So it could be the second date or the fifth date. The landlord will determine.
I actually don't know if the law determines that. I'm not certain on that.
Okay.
I'm sorry.
Or if it's like discretionary for the landlord to determine.
Right.
Okay, just read your leases, people, fully.
Yes, before signing them.
Yes.
Mm-hmm. Okay.
And check for extra fees in them because there's lots of junk fees. Sometimes.
Oh, wow.
We see junk fees from time to time.
And just to be clear, because Martin's platform is global, we're speaking on Illinois,
I'm specifically speaking on Chicago.
Right.
on Chicago.
And some of this applies to all of Cook County.
Okay.
Like the ERP program is Cook County. The court-based rental assistance is Illinois. But like the late fee calculation is Chicago. The rest of Cook County has a different math equation.
Got you.
Wow.
Okay. So just to be clear.
Yeah.
So now, you know what? I know we've asked a lot and we're kind of wrapping down, but is it anything that we didn't ask, or is it anything that you know that you would, say, hey, you know what? If you take nothing away from this conversation, take this.
That is a really good question. I think a couple things. Go to your first court date.
Mm-hmm.
So you can get that. You can get ERP, early resolution program, and you can talk to you can talk to an attorney. So that would be I think the biggest takeaway. Also, a 5-day notice. You just have to get the 5-day notice. It doesn't need to be notarized. It doesn't need to be served by a sheriff. A 5-day notice for non-payment of rent or any sort of notice terminating the tenancy. You just have to get it. So that's another thing I hear sometimes of like, well, it was taped to my door, but like the sheriff didn't give it to me. It's like, well, that's still a valid notice then.
Okay.
Everything
Okay.
you do it in writing. Make sure.
Yes. If there's conditions issues, let the landlord know in writing.
Wow.
And then
Call
wait.
311 if you're in Chicago. If you're not in Chicago, call your city hall. Because like every city hall has to have a way to report unhospitable building conditions.
Okay.
So call your city hall, find out where you make that report. And in at least Chicago, in Cook County,
Mhm.
I don't know if it's true elsewhere, but at least in Cook County, it's illegal for landlords to retaliate for reporting inhospitable living conditions. So if you report to 311 that your place is infested with like roaches, the landlord can't then just issue give you notice to leave because it's going to be presumed to be retaliatory.
Even if
And
you
like-
bought the roaches.
Except if like you also haven't paid rent, then that's like a separate issue, right?
Okay.
But like if you're current on rent and all you did was report these conditions to 311 and then the landlord suddenly gives you like a 30-day notice,
Mhm.
To leave. That's not allowed.
Yeah, that's
Or if the landlord cut off your lights, huh?
Yeah.
Yeah, that would be, yeah, the landlord doesn't have the right to turn off any of your utilities. That would be a constructive lockout. So, and then they don't have the right to change your locks once you, like after that 5th day and you haven't paid rent, they don't have the right to come in and just like change your locks or turn off your heat to get you to leave. Those would be constructive lockouts.
Wow.
Okay, I got another question. We got like 5 more minutes. Squatters. Have you ever did anything for squatters?
Do they have rights?
So I think that can get really complicated.
Okay, well,
Because sometimes we do see people getting scammed, where somebody's pretending to be the landlord, rents out this unit, takes the money and kind of just disappears. And then it leaves the tenants who think that they have a valid lease in a position where the landlord sees them as trespassers. And so things can get really, really complicated with that.
Okay.
So I think it depends on the circumstance and the situation.
Okay. One more question for me. This is the last question. I'm done, and you guys take over. When it comes to a landlord coming into your apartment, do they they can come in your apartment if it's an emergency, like if the water's running down on the. Okay, they need to know that, yeah, because some people.
Yeah, so there are rules for when a landlord can and cannot enter your apartment. In the normal course of everyday life, they have to give you 48 hours notice.
Okay.
And they have to have a valid reason to enter. They can't just want to come in just to look around. However, they can enter when there's an emergency. I had an apartment once where literally, suddenly, it was New Year's Eve and water just came gushing down from the ceiling.
Okay.
It turns out a hot water tank upstairs broke. They had the right to enter to see the fact that water was gushing down.
Oh, okay.
That's an emergency. But that's like the only time an emergency is when they can enter without notice. Otherwise, they have to give you notice in writing 48 hours ahead of time.
Y'all hear that?
And I was getting ready to say, so to that landlord, that, listen, we know you upstairs and you got this, nice chick downstairs and she running the shower water and you think that that's your invitation. Oh, I heard the water running and don't normally run at this time, so I just wanted to come check things out. You can't do that. Now, you can't do that.
Yeah.
Just want to throw that out there for free. So ladies, there is laws to protect you.
Yes, ma'am.
All right, I think that we've been on 42 minutes, 45. Any closing comments, you guys?
Thank you for being here and teaching us about, housing is a whole world of like the law. So this was a nice refresher, even for me.
And I want to just read this question.
Go ahead.
This person literally screaming.
We got 3 minutes now.
Yeah, okay,
Right.
it says, this person says, it's not proper service in Cook County for a landlord to post a 5-day notice to a door, nor take a picture and text it to the tenant. Landlords will have to show the court how they notified you, or the court will dismiss the eviction. And this person is screaming. So go ahead, John.
I would just say you have to get the notice. So the rule is just that you have to have received the notice. Okay. So like if they tape it to the back door and they know that you never use that back door, well then you probably never got the notice and it's probably still taped there, right? But if you got the notice, then you're on notice. The best way is like the landlord just to hand you the notice, right? So like just hey. And then like physically hand you the notice. But as long as you get it, you're actually on notice.
Can they send you an email?
No, it has to be, there has to be a paper notice
Okay.
that has to have a date, your address. It has to be signed by the landlord. It has to say how much money you owe or what other violation of the lease that you're violating, or it has to be that non-renewal we talked about.
Okay.
And then just as a disclaimer, well, let's say it again. This show is not intended to give you any legal advice. This is, just the podcast, the Martin G. Johnson Show. And everything here is just, information, but seek legal advice.
That's
Yes,
correct.
don't take legal advice from a podcast.
Now you have the foundational knowledge of some of your rights as tenants.
Exactly. And then when you have those specific questions to your specific case, that's when you go and ask an attorney for legal advice on your specific situation, or you go to the early resolution program and talk to a staff attorney there.
That number?
Our intake line is 312-347-7600. And that's if you have like a legal issue.
Right, and it won't
that
be
you
open
need.
until next year, right?
Right. It's closed until the new year.
All right, that concludes everything. I think it went perfect.
Yeah, me
It
too.
Went perfect. We didn't stay too long. We started on time. We're going to finish on time, exactly 45 minutes. Again, I want to thank Teamwork Englewood, the staff,
Yes.
and my partner Vera, and new
Jacqueline.
counselor here. I like to call
you.
him counselor.
Yeah.
She's the valedictorian of her class, so I had to throw that in there. So hey,
Well, hey,
she's
partner,
working, huh?
you already know what it is.
Live, uncut, unedited. Peace out, people. Thank you.
Thank you so much.